Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I want you to put yourself into the shoes of someone else for a moment. Picture, if you will, a man who has worked in the construction industry for 50 years. Now that's hot and often nasty work. You climb ladders, you crawl underneath houses. You fall off ladders. You work on roofs in the summer where the temperatures there can often reach 130, 140 degrees. You sweat and you labor and you save your money. You love the outdoors because you've worked there all your life. You especially love the wilderness. So you buy a piece of property on the edge of a wilderness in California in El Dorado County near Placerville. As you can see here, you're close to the El Dorado National Forest, Folsom Lake, and just over the Sierra Nevada mountains is Lake Tahoe. It is a wonderful place to build your retirement. Before you can retire, you have this one last building project to do. Your retirement home on the land you bought in El Dorado County. Because you're a contractor, you know the drill. You take your plans and you head down to the county to get a building permit. And that's where your plans for retirement meet the governmental mafia. Hey, nice land you got there. Be a shame if you couldn't build on it. How's about paying $23,000 for protection? Okay, so it wasn't the mafia. It was just California state government. Not that apparently there's a lot of difference. And it passed a legislative fee that when anyone builds out there, they have to pay a traffic impact mitigation fee. Except in this area of California, traffic isn't really a thing. And the rural area where you want to build doesn't have a lot of traffic, and your one little house is not going to cause enough traffic to require any real traffic mitigation. So you point this out to the county, and the county says, tough luck, you want a building permit? Pay me. So you have to pay $23,000 or you're not going to be able to build your home on land that you own, even if there's no traffic to impact, even if there's no traffic to mitigate. What do you do? Well, let me tell you what a guy named George Sheetz did. He paid the fee, got his building permit, turned around and sued the county. Now, his claim was that this was an unconstitutional taking, an exaction to be exact, and no pun intended there. And the two prior Supreme Court opinions said you couldn't do that. Now, affixing a set of blinders that would do Seabiscuit proud, the state court said, no, it wasn't an exaction because the fee was passed by the legislature. But wait a second there, homie. Let's look at that whole Fifth Amendment thing real quickly. It says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to twice be put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So the claim here is it's a taking because you're taking property without due process of law, and you're also taking private property for public use, not only without just compensation, but essentially that is the taking. You're taking money from this person for a public good without there being any real need for you to do that. There's nothing in there, as you can see, that says that the legislature is somehow exempt from the takings clause. Well, the Superior Court there said the cases that Mr. Sheetz cited all dealt with fees that were discretionary. In other words, that a county had the discretion to impose based on factors, and that discretionary decision was indeed constitutional because you had input into it. But you didn't have input into this legislative fee. Well, the court said the cases you cite all dealt with a fee that was discretionary, and this isn't discretionary because it was passed by the legislature, and the California legislature has no discretion. Okay, they didn't say that last part about the legislature not having discretion, but when a state has a $73 billion deficit, it's pretty clear no one in the legislature understands either debt or finances. And you have to remember that a billion is a million. And so when you have 73 million millions in terms of debt that you owe as a state, you can see where they want the $23,000. So George said, gosh, I don't think that's right. So he appealed. He told the state courts that to determine whether the fee passes constitutional muster, they should apply the test outlined by the Supreme Court in two property rights cases, Nolan versus California Coastal Commission and Dollard versus City of Tigard, Oregon. Those cases, taken together, hold that if the government wants to require someone to give up property in exchange for a land use permit, it must show that a condition is closely related and roughly proportional to the effects of the proposed land use. That certainly sounds fair. Not so in California. The California Court of Appeals affirmed the state court. It saw absolutely no problem with the constitutionality of this fee, and it refused to apply the two prior SCOTUS cases. So George took it to the Supreme Court. This case was argued in January of this year, and it was decided on April 12th. In a unanimous decision authored by Judge Amy Coney Barrett, the justices agreed with Sheetz. First, analyzing the degree of scrutiny for this legislative enactment, they found that conditions on building permits should be subject to heightened scrutiny even if that fee that they were imposing was authorized by legislation rather than imposed on an individual basis by administrators. At oral argument in January, Justice Neil Gorsuch observed that Sheetz and the county were in radical agreement on the question that the court had agreed to decide. The judges on Friday answered only that question in Sheetz's favor and sent the case back to the state courts to basically look at the case in light of the court's decision. The question that the court decided was whether there was some carve-out for legislative enactments, and the answer was a definite no. In her 11-page opinion, Barrett explained that nothing in the text of the Constitution indicates that the Takings Clause does not apply to fees imposed by legislatures. The same is true, she continued, for the history of the Takings Clause. In fact, she wrote, special deference for legislative takings would have made little sense historically because legislation was the conventional way that governments exercised their eminent domain power. Nor, she said, do the Supreme Court's cases interpreting the Takings Clause distinguish in any way between legislation and other official acts. So although the opinion was unanimous, in other words, joined in the result by all of the judges, there were some concurrences. Judge Gorsuch answered the question that was not decided, whether the Nolan-Dolan test operates differently when an alleged taking affects a class of properties as opposed to a particular development. In other words, in this case, Sheetz's case, it was not a subdivision that was getting put in there where they can impose this fee. Rather, it was a particular building that was at issue. He said nothing about the test depends on whether the government imposes the challenged condition on a large class of properties or a single tract or something in between. Now, the case only decided that it was a single tract, but he's saying, look, you have to have this rational relationship in between basically even when you're doing a subdivision. Well, while George Sheetz won on the question of it as applying to his property, the court refused to look at this other question of whether it applied to a class of properties, because the California Court of Appeals had refused to decide that issue. It hadn't really even considered it. And as a result, the Supreme Court refused to take it up because the California court needed to have an opportunity to address that issue before it would be ripe for review by the Supreme Court of the United States. Before you start jumping for joy for George, keep in mind that while the outcome was a win, it wasn't a complete win. And while Judge Gorsuch answered the question one way, in a one-paragraph opinion, Justice Kavanaugh wrote separately to say that the court had explicitly declined to decide the question that Judge Gorsuch posed in his concurring opinion. Therefore, Kavanaugh said, the court's ruling in Sheetz's case does not address or prohibit the common government practice of imposing permit conditions, such as impact fees, on new developments through reasonable formulas or schedules that assess the impact of classes of development rather than the impact of specific parcels of property. He said no prior decision of this court has addressed or prohibited that long-standing practice. So now the Court of Appeals of California will have the opportunity to review the case and the SCOTUS opinion and see how that comes out. Now, how it comes out is anyone's guess. It's interesting that the opinion here and the key expressions of those opinions were from the newest judges, Jackson, Barrett, Kavanaugh, and Justice. The arch-conservatives, Alito and Thomas, and the moderate conservative, Roberts, didn't offer concurring opinions. And they wrote on these separate issues regarding classes of property. Now, those are concurrences, so they are not the holding of the court. So why write? Well, the reason you write a concurring opinion in this case is to give the Court of Appeals a gentle nudge in what you consider to be the right direction. And when you have three judges joining in a concurrence, it suggests there might be some unanimity, at least with respect to those judges, on those particular issues. I'm just happy that the court decided the question the right way. So here is the TLDR on this case. First, Sheetz wanted a building permit, and that building permit was conditioned on an unconstitutional fee. And the holding of the court was the fee is unconstitutional because it was unrelated to any actual negative impact on traffic. It was just a legislative prescription. Other questions that we talked about earlier were not answered. So that's what I have for you today. Thank you so much for watching. If you have any questions, feel free to drop them in the comments down below or email me at the address above. I took a little time this weekend to spend with my wife, so I haven't actually looked at the comments from this weekend yet, but I will get to those today. Again, thanks for watching, and if you would, try to do a kindness for someone today. Open a door, close a door, anything that materially benefits someone, even in some small way, because kindness is never repaid, it's only passed on. And then, if you would, come on back down here and join me at the beach again tomorrow, and we'll talk about something else interesting. I try very hard not to be like all those other YouTubers who open up every video by asking you to subscribe before you've even seen the content. But now that you've gone a few minutes into the content, if you find this interesting and helpful, please subscribe. I'd consider it a personal favor. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.